The Supreme Court in the cited case sets out guidelines to assist the courts in the determination of the sentence where mitigation was not considered prior to the said case. Now, the guidelines are as follows, and I quote, "As a consequence of this decision, paragraph 6.4 to 6.7 of the guidelines, that is the sentencing guidelines, are no longer applicable. To avoid a lacuna, the following guidelines with regard to mitigating factors are applicable in a rehearing sentence for the conviction of a murder charge. The age of the offender being a first offender, whether the offender pleaded guilty, the character and record of the offender, commission of the offense in response to gender-based violence, remorsefulness of the offender, the possibility of reform and social readaptation of the offender, any other factor that the court considers relevant." We wish to make it very clear that these guidelines in no way replace judicial discretion. They are advisory and not mandatory. They are geared towards promoting consistency and transparency in sentencing hearings. They are also aimed at promoting public understanding of the sentencing process. This notwithstanding, we are obligated to point out here that paragraph 25 of the 2016 Judicial Sentencing Guidelines states that where there are guideline judgments, that is decisions from the superior courts on a sentencing principle, the subordinate courts are bound by it. It is the duty of the court to keep abreast with the guideline judgments pronounced. Equally, it is the duty of the prosecutor and the defense counsel to inform the court of existing guideline judgments on the issue before it. I have taken into considering all the factors necessary in assessing the appropriate sentence to meet the accused person in this case, as set out in the above case. Now, all these factors have been elaborated within this ruling. I must, however, mention that it has not escaped my mind that the offense in this case was a gender-based violence. It was a violence against a deceased person by virtue of being a boyfriend to the accused just because of perceived frustration the accused had in the relationship. Now, the Supreme Court decision, the same decision, the justices of the Supreme Court affirming the decision of the Court of Appeal in Godfrey Godho Mutiso vs. Republic, Court of Appeal case number 17 of 2008, and the High Court decision in Joseph Kaberia Kahinga and others versus the Attorney General 2006, Kenya Law Reports, stated thus: "We are in agreement and affirm the Court of Appeal decision in Mutiso that whilst the Constitution recognizes the death penalty as being lawful, it does not provide that when a conviction for murder is recorded, only the death sentence shall be imposed. We also agree with the High Court's statement in Joseph Kaberia Kahinga that mitigation does have a place in the trial process with regard to convicted persons pursuant to Section 204 of the Penal Code. It is during mitigation, after conviction, and before sentencing that the offender's version of events may be heavy with pathos, necessitating the court to consider an aspect that may have been unclear during the trial process, calling for pity more than censure, or on the converse, impose the death penalty. If mitigation reveals an untold degree of brutality and callousness," and I continue to quote, "If a judge does not have discretion to take into account mitigating circumstances, it is possible to overlook some personal history and the circumstances of the offender which may make the sentence wholly disproportionate to the accused's criminal culpability. Further, imposing the death penalty on all individuals convicted of murder, despite the fact that the crime of murder can be committed with varying degrees of gravity and culpability, fails to reflect the exceptional nature of the death penalty as a form of punishment. Consequently, failure to individualize the circumstances of an offense or offender may result in the undesirable effect of over-punishing the convict. The mandatory nature of the death sentence as provided for under Section 204 of the Penal Code is hereby declared unconstitutional. For avoidance of doubt, this order does not disturb the validity of the death sentence as contemplated under Article 26(3) of the Constitution. Now, the court has set out certain principles which should guide courts in sentencing, which I have applied in this case. The Supreme Court then dealt with the importance of pre-sentence hearing and entertainment of mitigation from accused persons, among others. The court has made clear exactly how the mitigation of the accused person should be applied by the court before the accused is sentenced. The court stated that it is during mitigation, after conviction, and before sentencing that the offender's version of events may be heavy with pathos, necessitating the court to consider an aspect that may have been unclear during the trial process, calling for pity more than censure, or on the converse, impose the death penalty. I have taken into account what has been presented by the accused person in this case as a version of the events. Is her version of the events of the material day heavy with pathos that would necessitate this court to consider an aspect that may have been unclear during the trial process? Pathos means anguish, bleakness, despair, tragedy, sadness. That has not set. Okay, the accused has not set before this court anything that would lead to a finding that there was an aspect of the case which remained unclear at the trial, which her mitigation could have illuminated. The events of the day were clear. Conversely, the accused person has not alleged that she acted out of any despair or anguish or bleakness or sadness or tragedy. I find that the accused person deliberately stabbed the deceased with the clear intention to cause him pain, suffering, and death, and I've taken into account that she stabbed the accused person 25 times. Now, in terms of sentence, the sentence for murder is the death penalty. It is true that pursuant to Murateto case, Supra, the courts now can exercise discretion when considering and passing sentence. It is important to say that, in my view, that discretion to pass a sentence other than death in capital offenses should only be exercised in the deserving cases. I do not find this a deserving case. I think to pass any other sentence than the one prescribed would turn the accused person to a hero. I want young people to know that it is not cool to kill your boyfriend or girlfriend, even where you feel disappointed or frustrated. Don't do it. Instead, it is cool to walk away and thereafter to forgive. Now, after considering all these factors, I find that the only sentence to pass in this case is death. I'm therefore sentencing the accused person to death as prescribed by the law. She has a right to appeal against the conviction and sentence within 14 days. Yes, I said it is. You are right. Yeah. So you can get at on payment of the reasonable charges.